Chris Hensley is a registered representative of Cambridge Investment Research, Inc., a broker-dealer member of FINRA SIPC, investment advisor representative of Cambridge Investment Research Advisors, Inc., a registered investment advisor. Cambridge and Houston First Financial Group are not affiliated.
The Houston Midtown chapter of the Society for Financial Awareness presents Money Matters with your host, Christopher Hensley.
Good morning, everybody. You're listening to KPFT Houston. I'm Chris Hensley. The time is now 10 a.m., and we have a great show lined up for you today. Impeachment is based upon those offenses which proceed from the misconduct of public men, or, in other words, from the abuse or violation of some public trust, as they relate chiefly to injuries done immediately to the society itself. That is a quote by Alexander Hamilton, and it is relevant to our topic today. We are going to be talking with local Houstonian and attorney Barbara Radnofsky, and she is the author of a book called A Citizen's Guide to Impeachment. So please stay tuned. Keep listening. We will do a deep dive into this topic. If you are a longtime listener, you know that we always reserve just the first few moments of the show to tell you a little bit about what's going on in the financial literacy space here in Houston and the Gulf Coast region. And we are super excited to let you know that Houston Money Week 2018 is kicked off. It actually kicked off last year around November, and we have been building it up each and every month, but we are officially here in 2018. We're at the beginning of the year. We have a partner meeting coming up next. Let's see. The leadership team meeting is next week, and the week after that is going to be a partner meeting. So we encourage people to come out, find out a little bit more about Houston Money Week and what we are all about. The website for Houston Money Week is houstonmoneyweek.org. And just to tell you a little bit about what Houston Money Week is, this is Houston's local representation of Financial Awareness Month that takes place every year in April. It started out 10 years ago. We are officially celebrating our 10-year anniversary. It started out 10 years ago as a week-long celebration of financial literacy. Had under 100 different organizations, groups, companies, local city government, universities, high schools involved with it, and it has morphed into many, many different partnerships and hundreds of different organizations participating. It has gone from a week-long event to a month-long event, and all of the different groups have something in common. We bring financial education for free to local, used to be low, moderate income, but that is not the case. It's actually that's a myth. All financial, economic liberation, financial independence, it goes through all different classes. So even high income earners have debt. They have credit card debt. We help people with taxes. We help people with student loans. But if this is something that you are interested in finding more information out, I would encourage you to go out to the website houstonmoneyweek.org, learn about us. We are a citywide initiative, community-based initiative to bring financial literacy to Houston. And with that, I want to make sure to have, we've got a really good topic today, and I want to make sure to have the most time to spend with our guests. So let me go ahead and get our guest on the line right now. Barbara, are you there?
I am. Thanks for having me, Christopher.
Absolutely. Very excited to talk with you today. You're a Houstonian, so that's always good. Most of our guests are outside the Houston area, so it's excellent to have you here today.
Yes.
I kind of start the show the same way, so I'm going to share your bio with listeners so that they can get to know you just a little bit better here. Barbara is a lawyer since 1979. She's a mother, a wife, a teacher, mediator, and arbitrator. 2006, after 27 years of law practice, she left Vinson and Elkins as head of the alternate dispute resolution section to become the first woman Texas Democratic U.S. Senate nominee and later the first woman Texas Democratic Attorney General nominee. Barbara was honored as the outstanding young lawyer of Texas in 1988. You practice on both sides of the docket, and you were listed for more than 25 years in the best lawyers in America. Once again, you also co-founded the National Association of Urban Debate League and has served on numerous local charitable boards. Okay, I'm running out of breath. And as a volunteer peer per mediation teacher in public, private schools. And then we talked just a little bit before getting on the air here that you were also a co-owner on the board of the Brazos Bookstore.
And with a number of other couples, yes, it's one of the nicest things in the world to be involved with an independent bookseller.
That is awesome. I am also a book person, so that kudos for that, because that is huge. As we see a lot of the even the major chains that have closed, and so the independents that are holding out in the book space, please keep doing that.
Absolutely.
Well, with that, let's do kind of a deep dive, and I think it's extremely relevant. We had a couple different things in the headlines and in the news when it concerns the presidency happen overnight. So that if it wasn't relevant, which I believe it completely is, but if it wasn't, it's even more so at this morning, as early as this morning when we start looking at the headlines. You have written a book called A Citizen's Guide to Impeachment. Can you tell us a little bit about why you wrote that?
I wrote it really to have a greater understanding of what is impeachment, and I have to admit, after a year of working, I was greatly surprised that impeachment doesn't involve crimes or misdemeanors, it doesn't require a crime or misdemeanor, and that it is exactly boils down to your initial quote. You read from Alexander Hamilton about injuries to society itself. I learned that impeachment has as its purpose by the Founding Fathers to remove a high officer because of the harm he poses to society. It's not a civil process. It's not a criminal process. It's a uniquely political process that Hamilton and the other Founding Fathers insisted we have for the very reason that we'd had a revolution against a tyrant, King George, and they didn't want to have his type of impeachment that he was using to lop off people's heads for treason. They wanted a modern impeachment, and that's what they gave us. And it's for harm, including economic harm, financial harm to both the vulnerable or the wealthy, harm to society and the people that compose the United States.
Wow. So when you talk about checks and balances, this sounds like really one of those things that was written in there as a fail-safe, as a circuit breaker, as a backup plan to prevent some of these tyrants and these things from happening historically. There's a couple of different...
You hit the nail on the head. As a matter of fact, it's one of the most powerful. It's unique because the sole power lies with Congress. In other words, nobody can overturn an impeachment. It's not even appealable to the Supreme Court, not like a criminal conviction or a civil matter.
So there's some history to this. Can you tell us a little bit more about the origins of the impeachment law?
Yes. Well, the Founding Fathers knew a lot. Many of them were lawyers trained in Britain. They knew about impeachments that were happening over hundreds and hundreds of years in Britain, and they brought their knowledge of impeachment to the Constitutional Convention as they were setting up the three separate branches of government and deciding what to do. As they went into the final debate on whether or not to be able to impeach a president who had been duly elected, the big debate was, should they do it just for treason and bribery, which were the two pieces of language they had in there, or should there be a catch-all phrase for presidential misconduct, something that didn't require intent? And Madison and Mason, two of the wonderful Founding Fathers who were there at the Constitutional Convention, had a most dramatic debate, and if you're wonky like me, you find it most exciting, and if not, you can read all the footnotes in the book, because I only give 88 pages to the text so normal people can understand, but if you're real wonky, you can read the details. And what they debated about, because there was an ongoing British impeachment trial, was the need to have a way to prevent a president, and they were really worried more about the federal office of president as they concentrated on impeachment. They didn't want a president who would engage in maladministration that would harm the country. But it would have to be a degree of harm that would be serious enough to warrant removal of the president. And they gave the sole power to the Congress. The House tries the case. The House is the prosecutor and the Senate tries the case. So the House acts like a prosecutor, brings the charges. They're called articles of impeachment. And then if a majority so vote on any article of impeachment, that one goes to the Senate, and all the votes that are in the majority go on those articles to the Senate. Then the Senate sits literally as the jury and the judge. Sometimes you'll see a Supreme Court justice, the Chief Justice, as the figurehead judge, but the real judges and jury are solely the Senate. And it is the only power which can't be checked. You talked about checks and balances. To balance the whole thing out, the Founding Fathers were so intensely fearful, having just won a revolution against an insane and petty tyrant, that they gave the sole power to Congress.
So that's a lot that you just said, because and I'm going to just recap some of it, because there was the idea of treason and bribery, but they wanted, you said Madison specifically wanted kind of a catch-all, added more there that was more encompassing, where Congress gets to almost act like a prosecutor. They absolutely do, but without any criminal punishment. And with the Senate getting to vote almost like a jury.
Exactly like a jury, each one on their own conclusions, but they also rule. They also make judge-like rulings on how can amendments to the pleadings occur. So it's both a judge and a jury role for the Senate, and they can form their own rules, and they have much streamlined rules since the 1980s, so that the Senate and the House can actually perform impeachments, and as they increasingly do, while still doing their other work.
So now you have been an attorney for a good portion of your life, but for the lay person who doesn't understand a lot of what I like to call legalese, as we go through this impeachment really process, there's a lot of legal principles that we might need to learn about. What would you say are some of the biggest legal principles that as a citizen we should be aware of?
Well, I think it's a very straightforward process, because the House doesn't have to use the legal rules that a prosecutor uses, and so you'll find different styles occurring. But the basic legal principle to keep in mind is this is a political process, a proudly political process that is intended to be the regularized process, and that's the words of the Founding Fathers, that is an alternative to tumults and insurrections. And so when the House goes about it, usually they'll refer when a congressman, and only a House member can initiate impeachment. They'll usually refer it to a committee, sometimes to Rules, but more likely to the Judiciary Committee. And it is not a civil proceeding. You've heard about these lawsuits on emoluments, for example. Those are civil lawsuits. And it's not a criminal lawsuit. You've heard about questions whether the president can be indicted or convicted in office. That's a criminal prosecution. This is a political prosecution, and the only penalty is if you're convicted, you're removed from office. That's it. So double jeopardy doesn't apply, for example. We've had impeachments where judges especially have engaged in all sorts of financial conflicts of interest, and they've been successfully prosecuted, and sometimes acquitted and sometimes convicted. But impeachment is separate, and they are impeached on the same operative set of facts. But what the House does is independently prove up that both impeachable conduct or misconduct or negligence has occurred, and especially they show harm. And then if the House votes on those kinds of financial conflicts of interest as impeachable, the Senate then has the trial. So it's not a criminal proceeding. Criminal proceedings are entirely separate and sometimes have occurred on the same set of facts.
So I'm learning right now, and I'm taking notes here. But that is kind of a perception out there that what's going on. There's this kind of intertwined idea about the criminal aspect of it, but that's a separate issue from the actual impeachment process. That is two separate things. It can be.
They can be related. For example, there are some crimes that would qualify if they're also independently proven as impeachable. But you can commit a crime as a high officer and not be impeached. And indeed, folks have committed supposed crimes, and they have not gone on to be impeached. The whole process didn't work it out, and they were either not impeached or not convicted. So it's entirely separate, and yet you will find that that information, of course, and data that's gathered is used by the House when they gather evidence, and they can do independent evidence gathering on their own as well. There's been some brilliant 21st century federal impeachments of judges, including Sam Kent, by the way, the Galveston judge who was abusing and sexually assaulting his employees, and he was a federal judge. He was in federal prison for obstruction of justice and lying about his sexual assaults, and he still wouldn't resign his high office, even though he'd been convicted of a crime. And the only thing that made that man resign and no longer be Judge Kent in prison, but merely convict Kent in prison, the only thing that caused it was the House impeaching him, and the Senate stood ready to have the trial. And finally, that man resigned his highest office.
Wow. So he was stubborn there all the way, even in prison. He was trying to resist the... Wow.
Absolutely. He wanted to keep all the benefits of high office, including very lucrative pension.
Well, so some of the research that you did on the book, you talk about federal impeachments in the United States. That's an example. Do you have other examples kind of historically of federal impeachments?
There's 19 examples in the book of federal impeachments, and I think one of the most significant is the first impeachment conviction in history. It was of a judge who had been appointed by George Washington, a very beloved Revolutionary-era hero, and Washington had appointed him, but he'd gone senile. And so the real question came when the Senate realized that they had a senile judge, well-liked, and his defense, presented by his son, was the man's senile. He has no intent. And yet the Senate knew that the judge was depriving litigants in the court, including, by the way, the United States of America, who was deprived of the right to appeal and weren't allowed to even put witnesses on. The ultimate decision was he was impeached and convicted. And, of course, the only penalty was he was removed from the bench and society was protected. And it is a wonderful example that's been disregarded over the years, and I've really resurrected this example because anytime somebody tells you you require a crime to impeach, you have to have intent, it's absolutely untrue.
So this just bubbled into my head here because as a financial advisor, I work with a lot of, in fact, I specialize in retirees, and when we talk about long-term care, we talk about Alzheimer's, Parkinson's disease, cognitive degenerative diseases. One of the litmus tests is, can they pay their bills? Can they do these things? This sounds like, in Washington's times, even before this was known, a safeguard to prevent when people's minds break, but maybe they're physically still able to show up for the job, but their minds break, and these are the people that are in charge.
And by the way, what you're talking about, this incapacity or incompetence, was one of the two examples that Madison gave. Madison really was a genius on impeachment and spoke about it not only at the Constitutional Convention, but in the first Congress when he was a congressman. And what Madison said was that he feared most either incompetency, that is incapacity of the president, or corruption. And either of those could be fatal to the republic. And he absolutely argued for impeachment as a necessity. And he won the day in all the debates. And so the exact point you make, that is, there's no intent required. One can even feel quite sorry for the individual who has grown incompetent or is just not up to the job. But to protect society, and because there is no punishment phase, you can remove such people. And the Founding Fathers made it clear they wanted impeachment to be used as a regularized process, as I mentioned before, instead of insurrection, revolutions, and all the tumult that would accompany trying to somehow find a way to get rid of such a person without lopping off their head.
As a safeguard, a preventative measure where people don't have to be out in the streets for us to make change. It doesn't have to get to that point to correct an issue like this.
Yes, and since the time of Nixon, and really since the 1980s as well, impeachment as a process has been increasingly used by Congress, both House and Senate, because having streamlined the rules, having gotten it right and understood the process. With the Clinton impeachment, it's really come to the fore in terms of understanding how it can be efficiently done. Impeachment is now a quite regularized process. And the older books talking about be careful about it or to be fearful of impeachment, now we understand this is what the Founding Fathers intended to be used, particularly at the highest executive levels. And it includes cabinet members, by the way. Cabinet members haven't been impeached.
And so when I think about impeachment, I think of Nixon. That's the first thing that pops into my head. As you were researching the book, historically, can you maybe talk about some parallels or what you saw with Nixon and impeachment?
Yes. Well, the Nixon and the Watergate process at the time it was happening is celebrated by everyone from Chief Justice Rehnquist, who wrote a book that lauded at the end of it when he talked about impeachment, lauded the bipartisan effort of the Watergate efforts. And the irony is most people think, they forget that Nixon wasn't actually impeached. He saw the handwriting on the wall. The investigation was ongoing on a bipartisan level, and the Nixon tapes had been denied by Nixon as having bad information on. He'd lied about what was on the tapes, and because of Judge Sirica's decisions upheld by the Supreme Court, it was learned that Nixon had lied, and that really caused Congress and enabled them to have the Judiciary Committee of the House bring out articles of impeachment. Nixon, seeing the handwriting on the wall, resigned. And so it's a wonderful example of how the system works even when Congress doesn't get to vote on the articles that are going to be pending before it. It's like the Kent case. The very willingness of Congress to stand ready to impeach causes the downfall of a tyrant who was abusing his power. Now, the pardon of Nixon stopped obviously stopped his criminal process, and there was attention lost to the great misconduct of Nixon. But it still is a wonderful example of the system working. And the other wonderful thing that emerged after Watergate was the effort of the House Judiciary Committee staff in 1974 of writing a report on presidential grounds for impeachment. And that has been frequently cited, and if you look in the footnotes to my book, the Citizen's Guide to Impeachment, that's the most frequently cited entity because it's just so brilliant and clean cut and has been praised by Chief Justice Rehnquist as well.
So as we talk about Nixon, it at some point I remember learning that he didn't get impeached, but it was almost to that point, and that kind of set the wheels in motion. And that's showing the system working. It's showing that safeguard is in place. But you did mention that the safeguard itself is a bipartisan. It's not one party in particular. I'm going to sidestep here for a moment because one of the things about the book is that once you published your book, you actually sent a copy of it, not just to any particular party, but to every member of the House and Senate. Can you tell?
The Melville House Publishing Company, bless their hearts, started a campaign through their generosity to get the book in the hands of every congressperson, and they they slashed the price and undertook all the efforts to have it sent, mailed, and conveyed with a letter. And so if you go to the Melville House Publishing website, which is MHP, Melville House Publishing, mhpbooks.com, you'll see their campaign, which got it very quickly to every senator, and I think they're well on their way to nearly every congressperson. And that's gotten, it's a nonpartisan book, but certainly it's a politicized process, and everyone understands that. During Nixon times, it was bipartisan. During Clinton times, it was not bipartisan. And during the times of Andrew Johnson, it was considered partisan, and then you had what were called the Republican recusants at the time of, of Civil War, right after the Civil War, who actually went over on the side of the Democrats to do the right thing and acquit President Johnson. So what's the history of impeachment? Each of these 19 cases, I was so glad to realize when I read each one of them came down the right way. Bottom line, the House and the Senate ultimately reached the right decision. Sometimes the House would decide not to impeach. In the 19 cases where they decided to impeach, the Senate would sometimes decide to convict, sometimes decide to acquit. And in 3 of those 19 cases, the fact that the Senate stood ready to have a trial caused the person to resign. There's been many other resignations like Nixon's before the process even was able to get underway. It is an extremely efficient, regularized, and increasingly used process. And I was so glad, for example, the Clinton impeachment. It was wonderful to read about that. That resulted in an acquittal. And yet the Congress, including Lindsey Graham, who prosecuted the case in the Senate as a congressman, Lindsey Graham lauded the process. Chief Justice Rehnquist lauded the process. You found not just the Supreme Court Chief Justice, you found members of the executive branch. It was all what Graham said was a great cloud has been lifted from the presidency. So when we go through these trials, what we find is it brings issues to the light of day in an organized fashion, the way the Founding Fathers intended it to be done, and not with crises in the streets. It's what makes us really the beacon of democracy. It's why we have this great republic. And this, occasionally you'll see these things saying we should fear impeachment as if it's some revolutionary process. Not the way the Founding Fathers did it. They turned the British system, which, by the way, is considered obsolete because it doesn't have the protections our system has. They no longer have impeachment in Britain, not modern times, because Parliament has recognized that it is not adapted the way the Founding Fathers did it for us in the United States in the Constitution. So I can't tell you what a journey this has been for me to learn what a wonderful process it is. And we really have Madison and Mason and a handful, including Hamilton, who went on the road along with a number of other heroes that I tell the stories of in those 88 pages of the book that's the text. So really heroes for us at the state constitutional conventions.
I know we are bumping towards the end of the show here, but I would encourage people, I'm going to give the website for the book publisher again, which is mhpbooks.com. If you are on the podcast, there will be a link to that on the podcast as well. If you want kind of a sneak peek of what Barbara is talking about in the book, she has been published in an op-ed piece in the LA Times as well as the Washington Post. So if you were to Google her, you can look up these op-ed pieces, and it will kind of apply some of that to kind of put it in context as what's going on currently in our environment now. Barbara, we are right here at the end of the show. Is there something that I forgot to ask you that you would like to share with our listeners today?
Well, I would say as a bottom line, and the book concludes in this, everybody should vote who's entitled to vote. And that really was the culmination of what I learned from the book. These congressional races, where these men have and women have the sole power to decide whether to impeach and whether to convict, those are the most important races we have coming up. Everyone should get out and vote.
So don't sit in your lazy boy chair or your couch. Get up off your you-know-what and participate in the process there. Barbara,
let your Congress people know how you feel about impeachment, whichever way you feel. Let them know.
Thanks for listening to today's episode of Money Matters Podcast. If you enjoyed the show, visit us on the web at www.moneymatterspodcast.com. Drop us a line on SpeakPipe on the right-hand corner. It will receive any voicemails, questions, thoughts, concerns that you have about the show. In addition to this, we recently launched a Patreon campaign. Click on the Donate Now tab to hit the tip jar and find out what Patreon's campaign is all about.